So without any further ado, um, I would like to introduce our first speaker, Armando Cecatiello. Armando is a lawyer based in Milan, Italy, and Lugano, Switzerland, with over 25 years of experience advising on every aspect of family and children law. He's a member of the Milan Bar Association, and he founded Cecatiello Law Firm, which focuses on protecting individual rights and providing a human-centered approach to legal issues. His expertise includes separation, divorce, child custody, adoptions, and family asset management, both in Italy and internationally. He's a regular contributor to leading legal journals in Italy and collaborates with Forbes on legal topics. The floor is yours, Armando.
Thanks, Stefano. Today I will speak about surrogacy and universal crime, legal, ethical, and social reflection. Go next. Can you go? Okay. The Italian context and before the reform. We have a law about assisted reproductive technology law that since 2004 prohibits the surrogacy in Italy, and which explicitly this law prohibits in the country. The law aims was to protect the dignity of women and children, preventing the eyes of the law, the commercialization of the female body. And there was a specific provision about surrogacy. It's paragraph 6. Anyone who in any form carries out, organize, or advertise the commercialization of gametes or embryos or surrogacy or maternity shall be punished with imprisonment for 3 months to 2 years and a fine from 600,000 to 1 million euro. This was in Italy. Since 2004, there were so many issues about it because so many Italians used to go abroad where surrogacy was possible, and they come back home with kids with a birth certificate. So there were so many proceedings in Italy just to be recognized, to ask the recognition of the children in Italy. I just make a selection of these rules of our constitutional court. One of the most important is the 33 of 2021, where the court declared inadmissible a question regarding the recognition of parental status established abroad through surrogacy, emphasizing that is the legislative roles to align existing law with evolving society needs. Another ruling from our Supreme Court, United Section, so the most important court we have. The Supreme Court reaffirmed the no recognition in Italy of foreign birth certificate listing non-biological parents resulting from surrogacy agreements abroad. The court emphasized that surrogacy violates the dignity of women and children, considering it contrary to public policy. So the question would be how was possible in Italy to recognize these kids? We found that it was possible, and it was authorized even by the Supreme Court. We use the adoption, special kind of adoption. What happened that in 2023, we had the new law that amended the surrogacy and defined that surrogate as universal crime. So with law 169 from 2024, they amended the law of 2004 and extend the criminalization of surrogacy to act committed abroad by Italian citizens. So declare the punishable of even if legal in the country where it occurs. They add an article to paragraph 6, and it's if the act refer in a proceeding period, because proceeding period means the surrogacy, concerning surrogacy are committed abroad, the Italian citizen is punished according to Italian law. So now in Italy, surrogacy is a universal crime. What does it mean, universal crime? Universal crime in our system is usually reserved for crimes like genocide, human trafficking, and terrorism. And the point is there a proportionality and the legal consistency in these rules? This is a rule that was really criticized in Italy. We appoint, you can use the following. We identify risk of constitutional challenge in Italy, and of course, even conflict with the European law and human rights, ruling on the family and children rights. The consequence of this and legal implication of this law are for sure a legal uncertainty for family. Italian citizens, it's so common for Italians to go abroad to have surrogacy. So we have legal uncertainty for families. It's the next slide. And even impacts on children's rights. So there is no certainty for these kids. And we have even potential of constitutional challenge, because the importance to have certainty of the status of kids that we don't have. We can see even legal implication outside Italy. Extraterritorial jurisdiction impact on international law and sovereignty, and potential, as I repeat, with the European law and human rights. Then there was a big debate in Italy about surrogacy and these rules. I don't want to make my comments more ethic than, but the problem is women's autonomy versus protection against commodification. And our issue was child rights and the concept of family. And then we have an emotional dimension, is surrogacy exploitation or empowerment. Then we have to consider the child best interest. We have so many kids now that we don't know what will be their hands, even because our courts will persecute their parents. So one of the focus of now in the public opinion, especially in the Lawyers Association, is about the child rights to identity, family life, and legal recognition. And with this law, what happened? We are protecting children or creating a legal limbo for them. So I want to leave you with some key reflection. Can a universal law truly capture the complexity of surrogacy and balancing ethics, law, and human realities? I'm happy to reply to your question, and I give back to Stefano.
Thank you very much, Armando. Our next speaker is Professor Jens Scherper. Jens is Professor of Comparative Law at Aalborg University and founding director of the Nordic Center for Comparative and International Family Law. Until August 2022, he was Professor of Comparative Law at the University of Cambridge. His main research interests currently are in comparative family law. He has undertaken several major comparative family law studies, including comparative works on surrogacy, and is the editor of the International Journal of Law, Policy and the Family, and the book series editor of the ELGA Comparative Family Law series. He was recently appointed as independent expert to the Council of Europe's Committee of Experts on Access to Origins. Thank you, Jens. The floor is yours.
Right, yeah. Thank you very much for the introduction and indeed for inviting me to the seminar. Yes, I was going to say you can move on to the next slide. Everyone has seen the starting point, but I need to advertise my center, obviously. Right. The first comparative study that we did and that is the basis of the further work is the one that you have on the screen now. It seems like it's quite old, 2019, but most importantly, some of the elements that we have seen in that particular comparative study are still valid today, in particular the classifications to which I will return numerous times. So next slide, please. We followed, these are the classifications that we developed in a cafe in Cambridge, I'm about to say, when Claire and I were discussing these topics over and over. And in the grand scheme of things, we found that one can classify the various approaches to surrogacy in jurisdictions globally into these four approaches that we call the prohibitive, the tolerant, the regulatory approach, and the free market approach. There is, technically speaking, a fifth one, which is, oh, hands off, let's leave everything to the medics. But we didn't find that to be a proper legal approach, so we didn't include it in the classification. Now, we were rather pleased that the UN rapporteur accepted and worked with our classification later on in her reports, given that she otherwise is not was not particularly positively disposed towards surrogacy. She nevertheless found these classifications helpful, and as I said, they will return to my mini lecture a couple of times. Next slide, please. We followed this up with a second comparative study because we had a big gap there, and we found that jurisdictions in Latin America were an emerging market in many ways. So we teamed up with the Suprema Corte and a center based in Mexico, and we had the second comparative study. The book's actually available in Spanish, online, and free of charge. For the English one, you would have to pay. Next slide, please. We thankfully found that what we had written in the previous one still holds true, but we also found that surrogacy remains a controversial topic around the globe, that there are concerns, like they were voiced in Italy, as we just heard, about the exploitation of persons, in particular women, commodification of children and the female body, that there is a sale of children in particular, and that this is an affront to human dignity. And let's just make this very clear. There's absolutely no doubt that there are practices of surrogacy where all of these concerns are fully and utterly justified. We've all heard the reports of so-called baby factories, and the concerns are very, very justified. They do materialize in many parts of the world. Equally, although we must also concede that there are practices of surrogacy in many jurisdictions where these concerns are addressed, and the issues here on this slide actually do not necessarily arise. Next slide, please. And so after all of this, we found that our classifications remain valid. The prohibitive approach, which essentially says we do not want surrogacy, this is evil, and we do not want to see this in our jurisdiction, and we will do everything to prevent it, although the everything is debatable. Then we have the tolerant approach, as we termed it, because that means that we will accept some forms of surrogacy, or that we will accept the results of surrogacy, even if we prohibit it on our own turf. Then we have the free market, which basically is ultimately anything goes with some minor or no legal regulations. And ultimately, the regulatory approach is where a jurisdiction decides to give itself a proper framework for surrogacy in order to prevent the concerns that I just listed from arising. Next slide, please. What we also found in our comparative study, and even in subsequent work, this still holds true, is that the prohibitive approach is essentially a failure, and the tolerant approach ultimately had to capitulate to the realities of the global surrogacy market, which there is, whether we like it or not. So the reason for having either a prohibitive or a tolerant approach is that we have ethical concerns, and as I said, quite rightly so, there is commodification potentially, there is potentially exploitation. And the shorthand answer, usually from politicians, but also spiritual leaders, is therefore all, or commercial surrogacy at least, must be prohibited. And the result of such a policy that is implemented in a state or a jurisdiction is that no surrogacies, at least officially, are taking place in said jurisdiction, or only so-called altruistic ones. And we can have a long debate about that term, but this is not the place. However, we found that the result of such a legal policy is that the citizens, as Armando just said, usually just go elsewhere for their surrogacy and then return home with the child. In that sense, surrogacy becomes a privilege of the wealthy, because this means you must be reasonably well organized and funded. But crucially, and I am going to get quite agitated about this later on, so be warned, is that we simply the exploitation and commodification is simply exported elsewhere. So we're not preventing this from happening, we're preventing this from happening in our own jurisdiction. And as I've said previously and was criticized for, this actually is not a position a decent human being can take, to say, you know, oh, I'm here in my country, we're good, and whether women and children in other countries are being exploited, that I don't really care so much about. That is not a position one can take. In addition, there will be, in a case if there is a prohibitive or a tolerant approach, very often be problems with the recognition of legal parenthood, and that is to the detriment of the best interest of the child. And in addition, as I will also address in a minute, there is, of course, an element of gender discrimination, because we will easily deal with male infertility or structural infertility in many jurisdictions, but female infertility and structural infertility, as I call it, when a male same-sex couple wants to have a child, that we do not deal with so well. Next slide, please, which has a lot of text, and I apologize. So this is a quote, the classic, as we call it in the comparative area, by Justice Headley. And ultimately what it boils down to, and this is against the background of the current tolerance system in England and Wales, but no matter how commercial ultimately, and ultimately also how exploitative the surrogacy was that resulted in the child, once the child is in the jurisdiction, what else can we do? Because by the time the child is there, it's almost impossible to imagine a set of circumstances where the welfare of a child would not be compromised if we refused to acknowledge parenthood, which in England happens currently still through a parental order. And that, of course, is the big problem. Now, next slide, please. The jurisdiction in which I am sitting at the moment, having left the United Kingdom as a result of Brexit, is Denmark. So there was a very instructive case called KK and others versus Denmark. Classic surrogacy in the Ukraine, sperm of husband used. Whether or not the egg of the woman was who wants to be the mother was used is neither here nor there. Payments were made, everyone admitted to that, and that's that. Now, Danish law would always recognize the sperm provider as the father, which leads me to my wonderful mantra, the sperm always wins. Sperm rules supreme. The wife in this case could only become a legal mother through adoption, but Danish law expressly prohibits this if payments were made, so she could not become the mother. And the Danish Supreme Court, the Højesteret, after conceding that it would have been in the best interest of the child to make that order, held that the general preventative message is the one that needs to prevail. We want to prevent surrogacies that are commercial. We do not want to accept these in Denmark, and therefore we will not allow her to adopt the child. And she could have parent responsibility, though isn't that good enough. Next slide, please. The European Court of Human Rights said that was not good enough, and in my view, rightly so, because it is a violation of the child's right to respect of private life. So please note that we're not dealing with a parental position, but rather the child's right, which also explains the European Court of Human Rights decision in Paradiso and Campanelli, because there it was not the position of the child that was voiced properly, because the child was not part of proceedings. The court in this particular case held that the margin of appreciation of the national legislature was limited when it came to such highly important areas as the right to an identity. And I have shortened this to being like a parent is not the same as being a legal parent from the point of view of the child. So next slide, please. And here is where I get slightly agitated, because the Danish law is a classic or goody two-shoes one, where they say, you know, we have high moral standards in our country. We do not want this kind of thing to happen. But the result is, first of all, gender discrimination, namely because the male person in an opposite or mixed sex relationship will always get what they want, provided their sperm is usable, because sperm always prevails. So the man will get what they want through the surrogacy. The person who cannot get it is the woman or the second intended parent, whether or not eggs were used or not, because we will not allow the adoption. That was the position under Danish law. And the fallacy of this is that this, of course, fails ultimately to achieve the policy aim. Now, if you put yourself in the shoes of the second parent and you're in a relationship with the first parent, who we shall call the sperm provider, and your sperm provider wants to start a family, and you do know that if you do this with a surrogacy in a foreign country, that you will not be the legal parent of the child under Danish law, but your sperm provider will be. And that you will get parent responsibility, and that you can live as a family, and that you will have a joint child that, even if the law does not say so, you will regard as your joint child. Would this actually deter you from going abroad? Let's just say that the number of cases we've had in Denmark are a very clear statement that it does not deter people. So if the ultimate motivation for the approach that Danish law took was to prevent surrogacy, it's just not happening. What Danish law succeeds very well in is to send people abroad, where they then have their surrogacy, and then they come home with a child. And this is where I get agitated, because, of course, we have no control over what happens in the other jurisdictions, whether there is any exploitation, any commodification, or many of the horrible things that we were so concerned about in the first place. But we turn a completely blind eye to this if we follow this particular policy. Now, the KK decision, next slide, please, put a stop to that. And I wish I could say that the law we have is now slightly better. Well, it is probably slightly better, to be fair. But we now have a two-prong approach, which also is not unusual. But one wishes that they had consulted people involved in this more closely, because we now are repeating in Denmark the mistakes that other jurisdictions made approximately 20 years ago. So first of all, we have a division into national and international. In national, only so-called altruistic surrogacy is permitted, but bizarrely, any kind of payment, of course, makes it illegal. There's still a debate on whether, if I pay the taxi for the surrogate to the hospital, whether that actually makes it a paid surrogacy. That debate is still on. But more bizarrely, medical professionals are still expressly prohibited from assisting with surrogacy in Denmark. So you can have an altruistic surrogacy, but not with the help of a medical professional. I will just leave it at that and not scream about it. Then for international surrogacy, we are now doing the blind eye procedure par excellence. It needs to be approved before fertilization. Gametes of one of the intended parents were used. So here we have improvement. It can be the ovum. It doesn't have to be the sperm. It can also be both. So here eggs and sperms are now in balance, at least. And then we need a declaration by the surrogate after birth that she wants to relinquish parenthood. Anything else we do not care about, which means we are opening the gates for exploitation in other jurisdictions, knowingly, willingly, and accepting this, because best interest of the child. Right, next slide, please. So that is dealing with prohibitive and tolerant approaches. The free market approach, of course, may have something to come into it, but we all know that when a market works, it works, and when it fails, it fails. And we can see in the surrogacy market that it fails much more often because of the wealth disparities that undermine the autonomy of surrogates, and they lead to exploitation and commodification. And I've put this example here, but if you could buy your own family, your own children, a future by selling your gestational function and your dignity, would you do it? And I like to self-test these on these questions. So if somebody said Jens, and assume I'm living in poverty, if somebody said to you, Jens, if we can have your testicles, we will give you enough money so that your children and your entire family will be financially safe. They can go to school and get a good education. Would you do that? And frankly, I would not hesitate a split second. They can have my testicles if it buys my children a future. So I doubt whether the so-called autonomous decision actually is one in many cases, given the prize that is to be had. That said, there are, of course, amazing surrogates out there who undertake the surrogacy freely and autonomously and knowingly and willingly and so on, but globally that may well be the minority because the majority of surrogacies happen in jurisdictions that are unregulated. So exploitation is happening, and the prohibition of surrogacy does not prevent it from happening. Another project that I hopefully will be concluding soon is a comparative study on criminalizing of surrogacy, which of course includes Italy as well, because Italy is by no means the first jurisdiction to criminalize surrogacy in this way, and also extraterritoriality attached to it. For example, Hong Kong and some Australian states do so, but the evidence, at least preliminary, we haven't finished the study yet, is that this ultimately does not lead to things not happening. It just attaches a stigma of criminalization to the parents in question. Next slide, please. So of the approaches that I've talked about, since I have, as my daughters would say, dissed 3 of them, that just leaves one, and that's the regulatory approach. That has its own problems, of course, but given that neither the prohibitive nor the tolerant approach achieve their self-proclaimed aims of preventing exploitation or commodification globally, as is just exported elsewhere, and I do not think that it is an acceptable position to say, as long as it is not happening on my doorstep, I'm fine with this. I do not accept this as a human being. The free market in many parts of the world fails to protect surrogates, and indeed also the intended parents and the children. That means, given that an international and comprehensive treaty on this is extremely unlikely, it seems that regulating surrogacy on a national level and making sure that surrogacies will happen in the jurisdiction question under circumstances that are acceptable seems to be the only feasible way forward. And I will conclude, next slide please, with a shameless plug for the 3rd International Surrogacy Forum, which will take place in the beautiful city of Cape Town in March, where we will get an update on one of the blank canvases, namely on what is currently going on in Africa. There's various bills pending, but also get an update on what is happening around the globe. And we will also be discussing the ethical issues surrounding surrogacy in these beautiful surroundings. The picture is actually of the hotel where the conference will be happening. So much for the shameless plug. Thank you.
Thank you very much, Jens. Thank you for that. It's time for our 3rd speaker now, our very own Colin Rogerson. Colin is head of fertility law at Mills & Reeve. He practices in children and fertility law, and most of his practice relates to advising on parentage issues following international surrogacy arrangements. He is a fellow of the International Academy of Family Lawyers and the Academy of Assisted Reproductive Technology Attorneys. He's also co-chair of the International Subcommittee of the American Bar Association's Assisted Reproductive Technology Committee. In 2024, he was awarded Lawyer of the Year Family Law in the Spears Awards for his work on surrogacy and fertility law. Colin, the floor is yours.
Thank you, Stefano. I'm going to start by just apologising in advance if I burst into a coughing fit, because I was at a conference last week overseas and I've come back with COVID, so timed that perfectly well. There we go. I just wanted to go over a couple of things, really. First of all, just an overview of the UK law, where we currently are and what might be on the horizon, and then some other developments elsewhere in Europe, but also in the US, which could have a significant impact, particularly on the US side, for UK-based intended parents. So as Jens indicated in his presentation, the UK falls within the tolerant classification of countries in relation to surrogacy. legal parentage is established post-birth in this jurisdiction by way of a parental order, and the statistics that we have for parental orders each year demonstrate that around half of the parental orders that are made relate to domestic surrogacy, and so the other half relate to international surrogacy arrangements. It's worth noting there that not everybody who undertakes surrogacy, particularly those who undertake surrogacy internationally, will apply for or obtain a parental order following the birth of their child, particularly if their child is born in a jurisdiction where the intended parents are registered on that birth certificate. They may not feel the need to formally secure their legal parentage in this jurisdiction. So I would think that it probably more than half of surrogacy births relate to international surrogacy for UK intended parents, but the statistics show that around half of them relate to domestic surrogacy. The UK was one of the first countries anywhere in the world to introduce legislation to regulate surrogacy arrangements, and it came in our jurisdiction in 1985 under the guise of the Surrogacy Arrangements Act. And this piece of legislation was introduced as knee-jerk legislation following the case of Kim Cotton. Kim Cotton was a UK surrogate who was working for a commercial surrogacy agency in the US, who acted as a surrogate for a Scandinavian couple. And her story was picked up by the British tabloids, and it caused a public backlash. In those circumstances, it might not come as a surprise that the law that was implemented does not particularly promote surrogacy, but it's also important to recognise that it has never sought to criminalise or prevent surrogacy in its entirety, and Parliament recognised that whatever law was passed, children would still be born through surrogacy, and they did not want to taint the birth of children with the criminality of their parents. That being said, there are a number of criminal offences in this country that relate to surrogacy, and that are perhaps one of the reasons why we do still send quite a long number of intended parents overseas to undertake surrogacy. First of all, there is a criminal offence for third parties to broker surrogacy arrangements for a fee. So this was probably primarily designed to ensure that commercial surrogacy agencies, the likes of which operate in most of the US, don't operate in the UK, but it also applies to lawyers. So lawyers in this jurisdiction aren't allowed to advise on or draw up a surrogacy agreement. And there are also offences around advertising a desire to be a surrogate, or advertising a need for a surrogate, which can make finding a surrogate difficult. The surrogacy organisations that operate in this jurisdiction lawfully are all operating on a not-for-profit basis. And the reality is that as matters currently stand, the demand for surrogates far outweighs the supply. We often refer to the UK as being an altruistic only jurisdiction in relation to surrogacy, but I always say that that's really an oversimplification of what the law currently says, because the criminal laws that relate to payments relate to the third parties. So it is a criminal offence for an organisation or a lawyer or a professional third party to broker a surrogacy arrangement for a fee, but the relevant provision in the Surrogacy Arrangements Act expressly provides that intended parents or surrogates don't commit a criminal offence by making such payments. Where that issue comes into play is when it comes to establishing legal parentage of the intended parents by way of a parental order, and that's because when the court is making a parental order or considering making a parental order, the court must consider whether there have been any payments that exceed reasonable expenses. If there are such payments, so if there are payments that are over and above reasonable expenses, the court has to authorise them before a parental order can be made. So that, I think, is where we get the the sort of notion that only altruistic surrogacy is lawful in this jurisdiction. The reality is that any payments that are made can be authorised, and we don't yet have any cases where the court has refused to authorise the making of a parental order. Parental orders are now available by single parents as well as couples. The couples don't need to be married. They can be in an enduring family relationship, which has been given an exceptionally liberal interpretation by the courts. The courts have made parental orders in respect of two applicants who are in a platonic relationship that intend to co-parent the child together. And there has to be at least a genetic link between one of the intended parents or the single applicant if it's a single applicant application. And that genetic link is a direct genetic link, so either the sperm or egg of one of the intended parents must have been used to bring about the pregnancy. We do have law reform on the cards. There is a very substantial Law Commission report, which was a joint report from the Law Commissions of England and Wales and the Scottish Law Commission, which was in March 2023. And that does include a whole raft of proposals to reform surrogacy laws in the UK. I won't go into the detail of that because we don't know exactly what's going to be implemented. But it seems to me that what they're seeking to do is to really tighten the ropes on what payments are allowed. So it would be creating a more altruistic model for surrogacy, but it would also allow a mechanism for parents in some cases to establish their legal parentage from birth, which would be subject to the surrogate consenting. So surrogacy arrangements would remain unenforceable, which is currently the situation under UK law. So a surrogacy agreement is not currently enforceable by or against any party. That would remain under the proposals, although there is a proposal that would allow surrogates to enforce contracts. So, for example, that deals with the situation of a surrogate who agrees to be a surrogate, and then the intended parents don't continue to make the payments for expenses during the pregnancy. She would have the ability to make an application or to make a claim against under contract law in those circumstances. It doesn't really impact on international surrogacy for the most part. It is there are some proposals that would relate to international surrogacy, and there's been a mixed reaction to the proposals from those who work in the surrogacy field in this jurisdiction about whether it's going to bring about the desired effect of encouraging more people to undertake surrogacy in the UK for the reasons that Jens has identified in terms of not wanting to export exploitation overseas, and we can't regulate what happens overseas, and so providing a safe and structured system in this jurisdiction is probably the best way forward. In terms of international developments, that it's not all doom and gloom in Europe. Belgium very recently has agreed to officially regulate surrogacy, which would permit altruistic surrogacy, but ban anonymous gamete donation. And it is suggested that under the new rules, that the new laws that they intend to bring in, the intended parents would be automatically able to obtain full parental rights from birth, and surrogacy will be available to unmarried couples and married couples, including same-sex couples. One big issue at the moment for anyone who is doing international surrogacy is developments in the US. The US has a long and well-deserved reputation as being the go-to destination for international surrogacy for those people who are sufficiently financially resourced to be able to afford it. Surrogacy in the US is incredibly expensive, but it has long been regarded as the safest destination. Now, for UK intended parents, there has been a huge benefit in US surrogacy because children that are born in the US at the moment are entitled to birthright citizenship. And President Trump, after his inauguration, signed an executive order that aimed to restrict birthright citizenship, or to say that they no longer recognized birthright citizenship. Birthright citizenship itself is not internationally the norm. So the US is one of only around 30 countries that has this system of jus soli, which is a system of birthright citizenship, but it's protected by the 14th Amendment to the Constitution, which does say that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. That seems fairly clear wording. And litigation is already underway. A federal judge has already put a pause effectively on blocked the executive order, but it's likely to be held up in the litigation system and could probably end up being decided in the Supreme Court. I think there seems to be, from the conversations that I've had with my various professional networks in the US, a broad consensus of what the outcome should be, which is that birthright citizenship should stand. But we don't know what will be decided by the Supreme Court. And we tend to know that, particularly in comparison to the UK, for example, Supreme Court decisions in the US can be politically motivated with political appointments. So we don't know what the outcome is going to be, but we also don't know whether there's going to be any exceptions to this. The executive order doesn't make any reference to surrogacy. And on one view, intended parents undertaking surrogacy in the US are not in the US illegally, but they would be probably on a visitor status. So again, we don't know what that impact is going to have. So practical considerations are that people who are undertaking surrogacy in the US really are going to have one eye on contingency planning. And working out how they can obtain travel documentation from their home country. And we have some experience of this. So in worst case scenario, if the US does bring an end to birthright citizenship and children born through surrogacy are affected, during the pandemic, the US government suspended issuing US passports, and so it was necessary for international parents, to obtain local passports before they could come home. At the moment, it's quite relatively quick and easy to obtain a US passport. I think it depends on the state, because the state will depend on how long it will take to get a birth certificate, but usually you can get a passport within a week or so of getting the birth certificate. But in the UK, for example, depending on a number of factors, including the marital status of the surrogate and the citizenship of the intended parents, there may be steps that you would need to undertake in order to establish legal parentage citizenship of the child before you can obtain a UK passport. And as a general rule, when you apply for a first foreign passport, a UK passport from overseas, it is going to take longer because it's done through consular processing. So it's not quite the same as when you used to be able to head down to Victoria Passport Office and get a same-day appointment. It does take longer. And again, UK nationals visiting the US under the ESTA scheme are entitled to remain in the US for up to 3 months. And that doesn't give you a huge amount of time or a huge leeway to resolve parentage, particularly if you travel out, as most people do, in advance, because you want to be there for the birth and you don't know if the baby's going to come early. So we're going to have to keep that under review. I think because of the number of people that are undertaking surrogacy in the US, that there will be a route or pressure for the authorities in the UK to give rise to a mechanism to secure travel documentation fairly swiftly, because otherwise it's going to cause some considerable issues. But hopefully that won't become an issue. The other issue in the US at the moment is obviously the political approach towards abortion. And that does have an impact on surrogacy because of the way that some of the abortion laws in the various states are worded. So I think it was a couple of years ago now, Alabama, in the context of a wrongful death lawsuit, found that embryos which were accidentally destroyed by a clinic resulted in wrongful death because they were given the status of being people. And so the effect of that was for some time until the Alabama legislature changed the rules. IVF was effectively suspended in the state of Alabama for a few months. And so if we see more and more states that impact on have laws that sort of encroach upon abortion rights, that could have an impact on fertility treatment in IVF. And of course, there are some circumstances in which a pregnancy, even a surrogacy pregnancy which is planned, there may be a wish and desire, or at least the option, to be able to terminate the pregnancy if something occurs during that pregnancy. So that could have an impact in terms of women who are perhaps not willing to be surrogates in the US. And so we'll remain to see what is the impact going to be for UK parents on US surrogacy. My view is that the US is still going to be the destination of choice, and solutions will be found. Maybe that's optimistic thinking on my behalf, but I do think that's likely to be the case. Thank you, Stefano.
Thank you very much, Colin. And thank you to all the speakers for your contributions. We're now going to open the floor for questions. Everyone can use the Q&A box. It's entirely anonymous, and you can ask questions to any or all of the speakers. We have one question for Colin. Colin, where are the best surrogacy destinations for LGBT intended parents at the moment?
So I think the best destination for LGBT intended parents at the moment would be the US, because they do have a established record of protecting, certainly at the moment, parental rights, and it's available. We are seeing, certainly in our practice, some other destinations. So Northern Cyprus, for example, is becoming quite popular. I'm a little bit concerned about that because the surrogates tend to come in from countries like Kyrgyzstan, etc. And in some cases, there've been, I know my colleague dealt with a case where the birth took place in Moldova, where surrogacy is illegal, and so that was, a concern there. But Mexico, Colombia, Argentina, until recently, Argentina has recently implemented restrictions on surrogacy. Canada's quite a good jurisdiction if you can find a surrogate. They have some restrictions that they're altruistic only, and so I think it's slightly cheaper than the US. It's still expensive, but and also the UK. If you're living in the UK, although surrogacy arrangements aren't enforceable and we don't have the most appealing laws, most surrogacy arrangements in the UK are unproblematic, and so you then avoid any risks over citizenship or being out of the country for longer than your visa entitles you to be in that country for.
Thank you very much. There are a couple more questions also relating to the UK framework. So I guess Colin's probably best positioned to answer these. So what are the issues with parents not applying for a parental order on return to the UK? Does this always pose a problem?
Yeah. So we don't know how many people don't apply for parental orders, but we have seen cases. Issues usually arise on a sort of triggering event. So the cases that you tend to see are cases where people have separated. So intended parents have separated. You're then in litigation in relation to the children, and then one parent says you don't have permission to bring this application. You don't have a status as a parent. The other issue could be on death. So if for example, in terms of inheritance, intestacy rules, there are issues in relation to trusts and seeking to establish beneficial interests in trusts, as well as citizenship. I mean, there was one case I did a few years ago where my clients came back to me with a 13-year-old child and said, we didn't apply for a parental order at the time because we didn't really know much about him, but we've just applied to renew our child's British passport, and there is a question on the passport form that says, is this child born through surrogacy? They ticked yes. The passport office asked them to produce their parental order. When they couldn't, the passport office said, in the circumstances of your case, your child's not British. You need to sort something out. And so they had to apply for a parental order then to resolve it. So there are problems, but sometimes they're not always picked up. So I think some people can fly under the radar because people don't necessarily know. A nursery administrator or a school administrator might not necessarily know enough to ask for that information. But it's, I suppose, easier in a way for mixed-sex couples to get away without a parental order, because if you have a birth certificate with two men on there, then it lends itself to ask why that, how that came to be.
Thank you. We have a question about Italy. So maybe for Armando. So someone's asking, will Italy really imprison parents who have surrogate children born overseas? Have the police actually started any prosecutions? What would then happen to the children? Would there be any legal recourse? Armando, you're on mute.
Okay. We have no news of any application of the new law until now. So we have a case of Italians that were coming from Argentina and they were stopped at the border, but they were stopped by the Argentinian authority. So until now, we don't have any cases. The problem is that we don't have an idea what could happen to the kids. And for sure, there is an open debate. What I can say that until now, it's a crime, but we don't know how much it will be prosecuted by our authority.
Yeah, if I might chime in here. So the comparative study we've done shows that in the jurisdiction where certain acts regarding surrogacy have been a crime for a very long time, there are no prosecutions. There is no sentencing. There may be many reasons for this, but the ultimate reason is that the best interest of the child is probably not best served by locking up the parents in prison, because in the jurisdiction in question, these two people are the ones who, even by the law, particularly with regard to the male, the sperm provider, as I call them, they are the legal parents, so you can't really do much about that. And so locking up the primary carers is not really conducive to the best interests of the child. And because usually in the country where the child was born, they are regarded as the legal parents, there really is no question of sending them back to the Ukraine or the US and saying, you live with your parents, because the law in that jurisdiction will actually not see them as the parents. So if we go back to the quote that I had on the screen very briefly, ultimately, if we take the best interest of the child seriously, then there really can only be the answer that it must be in the best interest of the child to remain where it is and with whom the child is, although there may be special circumstances, of course. And that is whether we like surrogacy or not. And also, if you look at the jurisprudence of the European Court of Human Rights, in particular, if the paternity has been established, not recognizing the parental relationship with the second parent is deemed to be detrimental, not only to the best interest of the child, but actually to the right of identity to which the child is entitled. So in that balancing act, it strikes me as extremely unlikely that any prohibition ultimately can be successfully upheld.
Thank you very much. We probably have only time for one more question. So going back to the UK, if the reforms to the UK law will tighten the rules on permitted payments, how will this be enforced? What are the options for enforcement other than refusing to grant parental orders?
Yeah, I mean, that's a really good question. The way that it's been drafted in the proposals is the permitted payments fall within a gateway that enables people to establish parentage without applying for a parental order. It requires a sign off and certain payments. So if payments have been made, then you wouldn't be able to go through that gateway. But the court would still have the option to authorize payments made because it goes back to the circular point. The public policy and the best interests of the child is paramount, and you're prejudicing the child's best interest by not having a secure relationship with their parents if you don't allow payments to be authorized.
Thank you very much, Colin. I'm not sure we have time for one more question at this point. Maybe one more for Armando. In terms of Italy again, what are intended parents doing in light of the new laws? Have they stopped going overseas, or are they still risking it? You're on mute, Armando.
I don't know. I really don't know because generally, and I can speak for what my intuition, it's not a fact, but generally very rich people do it abroad and stay for years abroad and then come back when everything is settled and then documents are ready and no problem. So I don't know if they are still doing, but generally it was in the past like this.
Thank you very much, Armando, and thank you to all the speakers for your contributions today and for answering these questions. And thank you to everyone for attending today. There is going to be, as I mentioned at the start, a feedback form. We'll be very grateful if you could fill it out. It will only take a couple of minutes. Well, thank you everyone for attending, and have a good day, good rest of your day.